Yeah.
Okay, Realty Pros, well, we're back for another Thursday training with the one and only Glenn from Velocity Title. So with that being said, Glenn, feel free to
Curtis,
take it away.
thank you. As always, you're too kind. So guys, let's just wrap up a little bit about what we were talking about last time we met. I'm not sure if everybody who's here today, if we have new folks, or if everybody that is here today was also here 2 weeks ago. So we were talking about the evolution of the transaction, the real estate transaction in the total, global scale, if you will. And what specifically we were talking about, of course, if you remember, was people signing electronically. Now, the real estate agents have really taken the lead on this, the real estate professionals, brokerages, and the industry as a whole, outside of the lenders and the title agencies, right? You guys have been using electronic contracts for some time. Everything's done primarily in a dot loop format. I think that's the one that I think you guys are mostly using, or at least that's what I see mostly in contracts.
Yeah, we use Brokerment now.
Which,
yeah, it's called
Brokerment. Yeah, that's right. Okay, so, and I imagine they do the same thing that dot loop does. And what that's called is a verification, right? It's a certified verification. And let me, you know what? I apologize. My document is damn near small print. I can't see. Let me grab my So specifically, it's a verification, and it has the person enters their name or their initials, and it'll say verified on a certain date at a certain time. And there's some numbers and digits underneath and behind it. And all that has important significance, right? It's got legal significance, and it's part of how documents get authenticated. So you guys have been advanced in leading the way in electronic forms of contracts as the industry has evolved, way in advance of title and way in advance of lenders. Now things are changing. So lenders now pretty much fully take loan applications electronically. They do not take a loan application face-to-face anymore, hardly at all, if ever. In fact, I'm not even sure that I know of one. I'd have to talk to Mr. Cooper to see how he's handling all of his, but I'm pretty sure he's doing it mostly electronically. I do know that I represent a few other lenders, and both of those lenders are if anybody is in their offices, it's amazing, right? Their offices are pretty vacant. All of the folks are working from home, and it's not just because of the COVID scenario. What it is that these loan officers and these processors can handle everything fully electronically. And you could argue about the merits of people not interacting in an office environment and having that face-to-face, human touch and human contact that I think is important. But nonetheless, the work can still be done from a remote or electronic evolutionary perspective. So as we go forward, there's no doubt it is going to be fully electronic. And so that has unique challenges that we didn't face in the face-to-face world, but it also has a lot of advantages. Obviously, if somebody is an organized person, they can set up a scenario where they are way more productive in developing their business model and sales and marketing by being able to do things remotely as opposed to doing things in a face-to-face environment. So a person can literally increase, and I've been reading from National Association of Realtors and other businesses that the productivity for a person in marketing and sales can be as high as 20%, which is huge, right? Think about it. If you're selling 10 properties in theory a year, right? Your productivity can go up by 10%. That's 2 additional properties a year. And you know what commission compensation is? That's a big raise. That's substantial. And if you're a 20 property producer, in theory, your production should go up by 4 transactions in a year, simply because you're effectively using this electronic environment that we're in now, right? You don't have to, the drive time is way down. People are now, and maybe somebody can, jump out. If you've had a transaction where the buyer has purchased a property and hasn't even physically seen it, but I've had a number of different transactions that have come across my desk in the last, let's just call it year and a half or so, that the buyers are purchasing properties that they have not even seen yet.
I closed on a property like that, not to cut you off. My last listing, the buyers, they just did an online view and they put an offer and we accepted it. And they had never even seen the house, like physically.
Yeah. Now think about that. That's, if more and more of that is going to happen, how much more productive you would be. And I think that we are going to see that. I think some people are still going to hold to, I really want to see that property before I buy it. But, and I don't know who just, because your name isn't on there and I'm not seeing pictures, but.
Sorry, that was Darlene. That's Darlene.
Hi, Darlene.
Uh-huh.
Hi, Darlene. So in Darlene's case, right? Think about that. People bought, was there a home inspection?
Nope.
Nothing. Okay.
Nope.
Well, those people were really interested and motivated to get into that property in some cases.
Exactly. Mm-hmm.
I can tell you that I purchased a property sight unseen, other than I hired an inspector out in Colorado, and it's a mountain property, and I personally purchased it and handled everything. Never left my desk here from the viewing of the property to setting up all of the inspections to dealing with the lender and then closing. Everything was done electronically, except for the closing folks actually overnighted me some documents. It's coming rapidly. And so we have to be prepared. Okay, why don't we get in, unless somebody has some specific questions about those issues and what to do from the perspective of how do we handle settlements if they're going to be handled electronically. We did talk about those documents, the important documents, right? Remember the deed, the note, the deed of trust last time we spoke, those really important documents, and of course the closing settlement statements, right? Those 4 documents were critically important. And to recap why they're critically important and why you should know about them is the note in particular, based upon a Supreme Court ruling in a case called Windesheim versus LaRocca, and as a Maryland Supreme Court case, and I represented the LaRocca party in that case, and it was a spinoff to LaRocca versus Northrop, Craig Northrop et al. And in that case, the Supreme Court ruled that based upon a 1903 law, which I disagree with the court, but whatever, they said they weren't going to buy my arguments. Based upon this 1903 law, it's called the signature doctrine rule. So if your client signs a document that is a contract document as a listing, a contract document as a contract purchase document, a contract document meaning all the documents at the settlement table, a note, a deed of trust, a deed, etc. The law deems, under law, that they have read and understood the entire document and they are bound to it, even where there could be a mistake in the document, intentional or otherwise. So that's very, very important to make sure that when you're sitting at the table, whether it's electronically or physically, that you're noting to your buyers, to your clients, okay, here are these documents. Let's make sure, is your name properly spelled on the deed, on the title to the document? I can't tell you how many times names as simple as that are misspelled, and it becomes a problem later down the road when they want to sell the property. Make sure that the tenancies are accurate. Remember the tenancies: tenants by the entirety, joint tenants, tenants in common, and of course sole owner, obviously, if it's a single person purchasing the property. So, and to recap, and this is why I like person to person for these things. And I told Jasmine, I'm ready to jump back in person to person when people are ready. But questions on tenancy can come up. So tenancy by the entirety, remember, is reserved. It's an ownership reserved to husband and wife only. And it provides for right of survivorship and judgment protection on the house. Critically important issue, judgment protection. Joint tenants, the right of survivorship, no judgment protection. So if, I'm going to jump back to tenants by the entireties in just a second on an issue that came up so we can talk about it. On a joint tenancy, if one of the people who own the house gets a judgment against them, it's going to attach to their share of the property. So a good deed would have a joint tenancy, which then becomes a tenancy in common if one of them has a judgment entered, okay, to the extent of their interest in the property. So let's say it's presumed 50-50, right? Curtis and I buy a property together, we're partners, we decide we want it as joint tenants, and we have a 50-50 interest. If I get a judgment against me, it doesn't impact Curtis's 50% share, but it does impact my 50% share on the sale of the property. The tenants in common is different because the tenants in common, if Curtis and I own that property together 50-50, we want to spell out specifically our share interest. Maybe Curtis owns 60% and I own 40%. We want to spell that out because at the time of a judgment against me, we want it to be very clear the judgment creditor is only entitled to my 40% interest, can't touch Curtis's 60% interest. And so in a tenancy in common, you want to look to specifically in the deed the percentage of interest. So that's really important. If you have some investors you're working with and they're not an LLC or they're not created as a company and they're just a couple of people together, you want to make sure if they're taking a tenancy in common that you understand exactly what their percentage interest is in the property, because it needs to be properly spelled out in that deed. That's one of the 4 documents. So now let's jump back real quick to the tenants by the entirety. Let's say you're taking a listing and it is a husband and wife. They're going through a divorce. And this happens a lot. When they took title to the property, they took title as husband and wife, tenants by the entirety. When the wife filed for divorce, or the husband files for divorce, doesn't matter who, the moment that filing hits the courthouse, the tenants by the entireties is severed. It no longer exists, which means that there's no judgment protection. If either of them have a judgment, it's going to attach. It also means that there's no right of survivorship. It severs upon the moment one of the parties files for divorce, which converts the ownership by operation of law. No paperwork is done. Just the moment they file for the divorce and it hits the clerk's hands and she stamps it, it becomes a tenancy in common.
Wow. Didn't know that.
Yes. That has been missed pretty much across the board. But it's really important that you know, if you're dealing with a divorce case, that you get a full understanding of what their situation is financially. They can, if it's important, prior to the divorce, change, and there may be reasons why it isn't very important for estate purposes. Maybe they have kids and some other things that they want to work on, to file for the divorce and then change the deed by refiling a new one in both their names. So it's John Smith and Sally Smith to John Smith and Sally Smith as joint tenants, granting each of them the right of survivorship. Because if during the pendency of that divorce, one of them passes away, and this is what happened in my case, the judgment's attached to the property and there's no right of survivorship. So why is it important if there's no right of survivorship? Okay, I own a property with my wife, Kathy, and Glenn's got a little too flirty one day with some pretty girl, and my wife didn't like it, filed for divorce, and one thing leads to another. Immediately upon the filing, right, we have 2 adult children. She severed the tenancy. It becomes a tenancy in common. If I pass away during the pendency of that sale, everybody thinks, well, it's the wife's property, right? No. If I had 2 children, even from a prior marriage, a share of my interest goes to the kids, and now the kids have ownership interest in the property immediately upon my death. So there can be reasons why, and divorce attorneys, I talk to them about this all the time. There can be reasons why in a divorce case, you want to have the divorcing couple file a new deed into a joint tenancy, because by operation of law, it's going to convert to a tenancy in common immediately upon the file. So that's critically important. If you're dealing in a divorce case, feel free to give me a call. We'll talk about it. We'll see if there's some reason, hopefully the parties are somewhat amicable and can work through whatever it is necessary. A lot of times the sale of the property doesn't happen until after the divorce is final and there's an agreement or an order from a court. So we'll look at that too. Those orders from the court sometimes impact what's going to happen. So if you're taking a listing, and today really we want to focus on listings. If you're taking a listing from a divorcee couple, there's some extra boxes you need to check. Make sure the transaction is one of the 2 different parties isn't pissed off down the line when settlement comes and things aren't working the way they thought it was supposed to. So there can be some complications. Does anybody have any questions about that, or have you run into any case where you were dealing with divorcing couples and some issues came up?
Yeah, I was dealing with a widower who had remarried, and the issues came up, and it was a mess. That's all I can say.
Yes. Yes, that can be a mess too, especially if title to the property is not proper and some party dies, and you're dealing with a widow or a widower. They may find out that they actually don't own all they think they own. And if there's an estate that gets created, it may attach an interest in the property. And I don't know, Dee, if that was what you faced in that case, but there can be some complicated issues.
Yeah,
so feel free.
There was contention between the children,
Right.
and the you know, and the widower's new wife.
Yep.
That was
Yep.
a whole bunch of stuff, and it was never resolved amicably.
Yeah. Yes, that can be a real challenge when you have a remarried party and then a spousal interest claim and kids from a prior marriage who may or may not get along with the new spouse. And as Dee indicated, boy, that happens a lot. Dad remarries and gets married to some woman that the kids just are not going to accept. And so there needs to be some clarity in the documents. It can be done, but once the person passes away, it can be very, very challenging to overcome. And there can be, in-family fighting that happens that impacts the entirety of the transaction, as Dee found out. Anybody else have any questions on that point? Okay, so guys, I'm going to talk about listings, and I pulled a packet, listing packet from a porterhouse transaction, and went through it. And I want to talk about specifically the lockbox addendum. Does everybody, have access to a lockbox addendum in front of them? Or okay, are you able to pull it up? I guess I should have maybe, is that something that can be passed around, or people can pull up there?
Yeah, I don't know if they, I mean, unless you have the ability to, guys, to, get into brokerment. I mean, we
Well,
have
let me
it
see.
like in our listing
No, I can't
docs,
do that.
but I'm not sure how we could actually just like pull it up.
Okay, no problem. I presume everybody is familiar with the Maryland Association of Realtors.
Hey, Glenn, real quick,
Hey,
how you doing?
how you doing there?
Hey, Curtis, let me see. Glenn, you can go ahead and start talking. But Curtis, if you go into your brokerment and you hit the little middle box that says share screen, you should be able to share that lockbox addendum if you can just go into your brokerment. But go ahead, Glenn.
Thank you. So the reason why I'm picking on the lockbox agreement today is because of a particular provision within the lockbox agreement. So as a general rule, I imagine everybody here uses a lockbox agreement, or at least recommends the use of a lockbox on every listing, right? I mean, it just allows the easy access, et cetera. And there's some issues that come with that. So before I get into the document itself, I wanted to open up the floor to have anybody give me an example of something that has happened when a lockbox was being used that maybe a person who shouldn't have had access. Maybe something happened with respect to an injury on the property. Anything that may have happened, or any experiences that you may have relating to the use of a lockbox on a property. Does anybody have any anecdotal stories about that? Well, that's good. Silence. that means that you haven't had too many problems.
I had a issue one time, Glenn, with a gentleman that I didn't realize, but he was kind of squatting at the property, and he was very reluctant for me to put the lockbox on, but I just strong-armed it and put the lockbox
on. Well, good. So today, I really want to talk about what's the provision in the lockbox addendum. And if you get a chance to pull it up on the screen, we'll show everyone. But if not, people should take a look at this. And it's paragraph 3 of the lockbox addendum. And it's called an indemnification provision. And the indemnification provision is a provision. Okay, it looks like it might be coming up, screen share. All right. Now, is there a way to, you guys know the system? Oh, there you go. Got it. Okay. So let's look at paragraph 3. Paragraph 3, in consideration of the agreement of broker, named obviously below, to place or cause to be placed a lockbox on the property, the seller hereby agrees that the seller shall hold harmless and indemnify the broker, their agents, sub-agents, and employees, or any other authorized user of the lockbox services as licensed or certified appraisers who access the property through the lockbox and the applicable realtor associations, et cetera, et cetera. Okay. So what this is saying is, look, Mr. and Mrs. Seller, we want to put a lockbox on your property, which will have a key inside the lockbox that authorized persons who are part of the board of realtors can access your property, can access the lockbox, get a key, and access your property to show it to potential buyers. And so we're saying, in order to do that, we want you to indemnify us in case of something going wrong. Somebody stealing from your property, somebody becoming injured at your property, somebody leaving a door open. In other words, if we get sued as the agent, if Curtis is listing that property and somebody either is injured in the property or somebody does something inappropriate in the property or steals something from the property, that if the broker and the agent are sued, the sellers shall indemnify, meaning cover us for any loss. So how is this applicable? So in an example that we can use is pets on the property, right? So first off, when we're talking about pets on a property, I think it's really, really important. And I had a very good witness in a case recently. And it was a case relating to pets on a property. What is the agent's duty where there are pets on a property? So for example, and I'll throw this back to you guys too. If somebody has a parakeet in a cage in the house, is there a lawful duty to disclose that there's a parakeet in the house? Anybody jump in? Do you have a duty as a real estate licensee to disclose in the MLS or elsewhere?
This is I would think that it would be a responsibility of that person. I did experience something where someone had 2 dogs and they failed to mention that. And I went to go open the property and the dogs were at the window. If I didn't see those dogs in the window, I would have been attacked by those dogs because they didn't mention.
Great example, Aurelia, because that's really the thrust of what we're talking about today. Mostly dogs, and some people they keep snakes or other hazardous animals and things, and so you want to be careful. So let's talk about that. What Aurelia brings up, and what our example is number one: what is the duty of the agent under the Code of Maryland regulations, under any ethical standard? Does an agent, when listing a property, have a duty, or under the MLS, by the way, to disclose the presence of animals in the property? The answer to that is no. There's no legal duty to disclose. And the reason really for that is that if you undertake a legal duty, you are assuming responsibility for it. And then you can be deemed to have the responsibility to cure whatever that issue is. So let's say the seller has 2 dogs and maybe they are dogs of what's called vicious propensity. There's about 10 dogs on the list. Believe it or not, the big poodles are on that list, but you know, the 10, maybe or 11, 12 dogs, whatever they are. Rottweilers, pit bulls, German shepherds, you know, Doberman pinschers, a couple others. Those are all dogs that are predetermined to have what are called vicious propensity dogs. And so the question is, we are listing a property, the seller has dogs, what's my duty? And then what is my courtesy with respect to being a real estate professional? So in Aurelia's example, there were 2 dogs that were uncaged, they were unrestrained, they weren't in a constrained environment, so that if she opened the door, wow, she could have been seriously injured or attacked or worse. So immediately you go, what the hell's going on here, right? And you have 2 possible causes of action. One would be the owner of the property. When you're listing a property, you know the owner has dogs. While you do not have a duty to disclose to every possible person that there are dogs on the property, you do have a responsibility to express to the owner of the property, you're going to get calls through showing time, or I'm going to call you, and people are going to want to see your home. You must have the dogs restrained at the time of showing, right? There needs to be an acknowledgement by your seller. It's not a bad idea that that notice should be in a writing to your seller. Now, as a practical matter, you're going to put this property in the MLS, and if you know there are dogs, it's not a bad idea to put a little note in the remarks in the MLS, although you're not lawfully required to. So does everybody understand the difference between doing something as a courtesy for your fellow real estate agent versus a legal requirement to do something? So in other words, I don't have to put it in the remarks. I'm running out of room. I've got every other good thing that could be stated. But of course, as a courtesy, you might want to do that because you don't want to have Aurelia's example occur where somebody walks in and the seller has failed to properly follow your instructions. So go ahead. Somebody have a question?
Yeah, Glenn, I was just going to ask. So, because what I've seen where they did not put it in the MLS, but they did put it in the notes in showing time. Yes. Same thing, different thing. How's that go?
Well, that's basically the same thing. So
Okay.
It's a good point. You don't even have a requirement to put it in showing time. You don't have a lawful requirement, right? So if somebody got injured and then they wanted to blame you because it wasn't in the MLS or in showing times, there was no notice of it. Yeah, they might be able to make some sort of an allegation and make a claim. That doesn't necessarily mean that claim is going to be successful. But even if the claim continued to hang around, then we're going to go back to paragraph 3 of the lockbox addendum. And so there's really a couple of different issues that we're talking about. One was, what is my responsibility? What is my duty as a listing agent? And the second is, what is my courtesy to my fellow agents? And the third issue is what happens to me and to Porterhouse International should somebody bring a claim because they were either injured, or or scared out of their wits because of some aggressive dogs. So in Aurelia's example, let's say she actually did open the door. And as she was opening the door, she hears the dogs. She then sees them. They're running at the front door. They're leaping at the front door. She slams the door shut and she falls backwards and becomes injured, right? And maybe it's a reasonably serious injury and it requires medical treatment, etc. So she definitely has a claim and a cause of action. But the question becomes, against who? Who is her claim against? Is it going to be the owner of the house? Is it going to be the listing agent? Is it going to be both? So lawyers will usually try and file the claim against everyone, right? The sellers, the listing agent, the door company, everybody who might have anything to do with anything. And of course, what they're looking for is insurance, the deep pocket. And many times the deep pocket is the real estate company. They have an errors and omissions insurance policy. And the question is, if a listing agent fails to put a notice in the MLS or in showing time that there are dogs in the property and someone is injured when they went to see the property, my question for you is, would that be a claim that could be presented to your E&O policy, right, as an error or an omission for your responsibility in listing a property? Anybody care to guess?
I would say no, based on what you said as far as the law.
Correct, Aurelia. The insurance company is going to deny the claim certainly at least up front. They're going to say, I'm sorry, that's not your responsibility. That's not part of being a real estate professional. Your job is to list homes, sell homes, market properties. Your responsibility is not, and does not cover anything to do with pets and dogs and personal injuries related to that. So they're going to deny coverage, okay? And so that can leave a person exposed to legal expenses as a real estate licensee if they get named in that kind of a. So as a protection measure, I would say if you're taking a listing and there are animals in the property, then go ahead and put a note in the MLS and showing time, dogs present at property. But you don't have a requirement to do so. Now, paragraph 3 is so important to real estate professionals. And you should know this when you're taking these listings, because what it's saying is, if somebody's injured and I get sued because of it, you, Mr. and Mrs. Seller, are going to have to indemnify me and pay for my legal fees, pay for my defense. And if I lose, then you're going to have to pay for my cost of the loss, any claim against me. And the reason that's important is because the homeowner has a homeowner's insurance policy. The homeowner's insurance policy should cover personal injuries occurring on the property, regardless of whether it was by a listing, lockbox, a showing, or somebody just visiting the property. And people are generally, insurance companies will ask questions such as, do you have pets or dogs, or what kind of dogs, et cetera, et cetera. when they do your homeowners insurance policies. So when you are taking a listing and you see something that could cause you to potentially have an issue, you want to consider it very, very clearly. If you have questions, you can reach out to Jasmine, or you feel free to call me at all times. But when you're going through these listing appointments, make note of things that aren't necessarily just related to the property itself, but any possible hazards at the property. Understanding though, hey, we sort of have a little bit of a safety net here with respect to paragraph 3, because it does ask the seller to indemnify us in the event of a lawsuit or a loss. And that's critically important that you have this.
Hey, Glenn.
Yeah, go ahead, Shay.
Yeah. And guys, what I want to say to you guys is that, God forbid anything like this ever happens to you. When you get that call directly and the agent is saying, hey, I got injured at one of your listings, et cetera, please do not make any statements that would possibly cause us to take responsibility. You can express your condolences or what have you for the injury, but let them know that you're going to inform the broker immediately, and the broker will follow up with you.
Shay, do you mind if I follow up on that just a bit?
Absolutely. I just had to chime in.
I'm glad you did it. He brought up a fantastic point. Okay. A person can assume responsibility by accident, even not intending to assume responsibility. And that's why you kind of don't talk, but you never apologize, because an apology can be deemed accepting of responsibility for an injury like that. So what Shay is saying is, don't make comments like, oh, I'm so sorry I didn't put it in the MLS, or, oh, I'm so sorry of this or that. Don't say anything except, I hope you're feeling better. I'm going to get the information to my broker right away, and I'm sure somebody will reach out. That's it. Anytime anything happens, whether there's a claim for somebody did something wrong on a contract, or whether there's a claim for personal injury, or any claim whatsoever, if you get a call and somebody's making an allegation or a claim, whether it be injury or negligence in the contract or whatever, say, we will look into it, get in touch with our broker, and somebody will get back with you. That's it. Never say I'm sorry about anything like that. Unfortunately, that's the world we live in, because you can be deemed to be accepting the liability, or the mistake was yours. You're saying, oh gosh. That actually even applies to car accidents, by the way. Unfortunately, if you jump out of the car and say, oh my God, I'm sorry, that's called an excited utterance under the rules of evidence. And what it says is that when somebody becomes confronted with something that just happened, a call that says, so-and-so got bit by the dog, oh, they're bleeding, and you go, oh my God, I'm sorry, I didn't, because you're excited about whatever happened. There's an accident, you accidentally pulled out into the road and you got hit, and you go, oh my God, I'm sorry, I just didn't see you coming, I was taking the right on red, whatever. You have now accepted liability by doing that. And it's allowed into evidence as an excited utterance at the moment at which the person became aware of it. And the reason it's allowed is because human beings are funny this way. When we're excited about an event that's happened, excitement meaning either jubilation, anxiety, whatever excites our biological responses to an event, it's very difficult to lie in that moment. For some reason, in the excited utterance, and they've tested this time and time again, we immediately tell the truth at that moment as we know it. And so it can be used, actually, unfortunately, it can be used against us in a case. And of course, what Shay is saying is true. When something occurs or if something occurs, don't say anything at all except for, we'll look into it, we'll get back to you, we'll get with our broker, and then somebody there will take on. And then after that, don't talk about it at all anymore. That's the general rule. That was a good point, Shay. Very good point. And that works to protect you, and it works to protect your broker. Because they get dragged into anything and everything that happens to any agent out there. So does anybody have any questions on those issues? Notes in MLS, notes in showing time, or how to handle a situation with respect to showing properties that might have hazardous conditions? Everybody good on that? All right. So I see we have a few more minutes, right? And I want to take that time to really kind of open up the floor to anybody who might have some issue that I can go in a couple of different directions, but I kind of did want to open up the floor for anybody who might have some issue with respect to listing properties at all, whether it be family matters, estate matters, foreign person matters, right? That can be challenging. Corporation matters, LLC matters. Anybody have any questions or experiences that they want to touch base on?
I do. This is Darlene.
Yes. Hi, Darlene.
So right now I'm in the process of working with someone who's doing or who's going to be, right now she's waiting for her letter of administration. And she needed to do an appraisal. What would be the purpose of an appraisal for an estate sale?
Sure. So when somebody passes away, there's the court requires what's called an accounting. And the accounting is something that essentially takes into consideration all of the assets of the deceased individual. And so the appraisal gives the personal representative the value, the equity position in the real estate to present to the court, so that at the end of the closing of the estate, the personal representative can disperse all of the money to the penny and get a court approval on that. So what they're looking for is a valuation for the accounting so that they know the estimate value of the estate at that time. Now, in Maryland, we have two estates. We have a small estate, which is anything under $50,000, and then everything over $50,000 is a normal estate. So the small estates don't require a lot, and so if appraisal's done, and let's say the property is worth $350,000, and the person owes $335,000 on the house, well then there's not enough equity, and if they don't have any other assets to add to that, then they're not going to have an estate over the $50,000 threshold. It makes it much easier to administer the estate. So that's the reason that they're looking for the appraisal. That would always be required in an estate situation.
Okay, thank you for that information.
Yeah, no worries. Anybody else?
Hey, Glenn, it's Carmon.
Hey, Carmon, how you doing, buddy?
I'm good. Quick question. In Washington, D.C., there's a client that, or soon to be a client that, she's elderly. As a matter of fact, she's been diagnosed with Alzheimer's, and her children are her only living heirs. Yes. And they're going to probably put her in a facility and then sell the home. Now the home had what's the thing where when she gets 65, you put it on, then you stop paying the mortgage.
Reverse mortgage. It's a reverse mortgage. Mm-hmm.
Reverse mortgage. Here's the main question. One of the children is deceased. Other two children are alive. If they sell and they have to split the proceeds as the heirs, does the deceased person's heirs, does the deceased person's amount or share go to their heirs, or do the remaining live children split it?
Great question. Okay, so do you know, was there a will? Did this person have a will? Or
I don't think so. I don't think so.
Okay, so first, if there is a will, then the will control what happens. It's called a distribution, and this is a weird word, per stirpes, PERSTIRPES, stirpes. So if there is no will, the two surviving children, as the sole heirs, will split the entirety of the estate. And the kids of the deceased child do not get a share.
Okay.
If there is a will and the will says, upon my death, the interest of my real property and on my estate shall be dispersed to my then living children per stirpes, is what it will say. And what that means is that if there's 3 kids and one has died, and that one who died had 2 kids, it gets split up into 3. The 2 surviving children get their 1/3, 1/3, and then the grandkids, the 2 children of the deceased child, will get that 1/3 split into 50-50. Make sense?
Yes, indeed.
Okay, and that's how that's done. So if you're taking a listing with somebody who's near deceased and or has been deceased, then you want to make sure, if you can, get a copy of that will. If you guys have questions on it, when you do get it, give me a call and I will take a look at it. And I can help you instruct the beneficiaries as to what their share interest might be.
Now, is it too late for them to do a will at that point? Is it too late for them because they've been diagnosed with Alzheimer's, or?
Well, it just depends upon the stage. A person can have dementia or Alzheimer's, but not be deemed incapacitated simply because they have the disease. So we go through the stages of the disease. At some point, a treating medical professional will say the person is now mentally incapacitated. They can no longer understand or have the capacity to enter into contracts or sell properties or do whatever. So you have to find out how far along she is. She may not be there yet. And just because she has the disease doesn't mean she can't still handle some of her affairs lawfully.
Gotcha. Perfect.
Mhm.
Thank you.
Yeah, you're welcome. Estate is, oh, go ahead.
Oh, okay. My name is Christian. I'm just
Hi,
trying to say, yeah, how are you?
Good, thank you.
Great to see. I'm just trying to say, in a situation like that, if there was a will, then they cannot sell it until she dies.
Well, that is correct. The will only becomes effective or active at the time of death of the individual. Now, recently, I've been getting a lot of people, and what might be the best situation in the example we were just given is converting, if she does have the capacity still, mental capacity, right? She's still living. You may want to do a life estate deed, okay? And the life estate deed is a fantastic estate planning tool. Especially for older folks who want to make sure their kids are getting the property. So let me talk about just for a second what a life estate deed does. So I own the property, right? And I own it with my wife. We're getting up there in years. Now, I have 2 kids, and I say, look, I want to live in this house and be in control of my own affairs for as long as I can. At some point, I may die. At some point, I may want to sell the house. At some point, I might want to refinance the house, whatever. But I want to make sure that when I die, my kids get the house, and I don't want them to have to go to court and have to open an estate with a will or anything else. So I can create a life estate deed where I transfer the title of my house to myself as a life tenant for the remainder of my life with what's called full powers, right? I will have the power, if I want to sell the house and take all the money, refinance the house, do a reverse mortgage on the house. I can do anything I could do before, but I've changed title to have people put into the deed as what are called remainder persons. My kids, I want my kids. It could be anybody. It doesn't matter. It could be a charity. It could be anybody. But for me, I want my kids to be the remainder persons. So what I do is simply create this one document. I transfer a title from myself to myself as a life tenant, and then upon my death, let me rephrase that, to myself as a life tenant with full powers, and then upon my death to my 2 loving children. Done. I send it down for record. The court charges us $64.50. There's no transfer taxes on the transfer because I'm transferring it to myself. I already own it. The government cannot charge a new transfer or recordation tax on a life estate deed. It's a fantastic vehicle. If you have elderly folks who take title, or they don't even have to be that elderly, they just people who want to make sure that if something happens to them, their kids get it, but they don't necessarily want to have to go through the process of opening an estate, or they don't want to have to go through the process of the legal costs of all the wills, trusts, and estate work. Then it can be done for a couple $100, life estate deed. Easy, simple. I probably do 6 or 7 a week life estate deeds. So if you have clients, keep that in the back of your head. I'm happy to help them. And that answers, I think, Christian's question that yes, the will would only becomes effective upon death. But if you want to take care of some of the transfer issues with respect to real property, you can do it by the life estate deed right up front. Has anybody ever heard of a life estate deed before today? Have we discussed? I don't remember discussing it here.
No.
Yes.
Well,
Yes.
yes.
Yeah, we did it. For the exams, I think it's part of the preparation for real estate license.
Yeah, it should have been. Yeah, I would hope they would have it in there, and I'm glad we got a good number of people who said yes, they've heard about the life estate deed. I'm a big fan of it as an attorney, and I do a lot of estate work as well as what we do here because it just kind of goes hand in hand, right? Real estate and estate work kind of goes hand in hand. And life estate deeds are fantastic vehicles to use. Anybody have any questions on that? Because, well, you know what? I know my time is up, is over just a little bit, but since we're on this subject, another issue you want to be very careful of. There's all these little pitfalls you always got to watch out for. And that is Medicare liens, right? If you're dealing with an elderly person and they've been receiving Medicare benefits, they have what's called a 5-year look back. And they can lien the property that the person wants to sell. Even if they've transferred title, Medicare has the ability to look back 5 years before the sale and unwind that transaction and lien the property. So if you are dealing with an elderly person who you know has been receiving Medicare benefits substantially, or in-house care or something, and that Medicare has been paying the bill, that is a box that needs to be checked and cleared, because that Medicare lien will attach to the property at the time you're trying to sell it and can exhaust all of the equity in a property pretty quickly. So you want to, if you're dealing with elderly folks, particularly somebody who might be in a dementia or Alzheimer's state, and they may have been receiving Medicare benefits and treatment, you got to look at that. Okay.
Okay, Glenn,
Yeah.
I have a question on, and this is pertaining to what Kerman was saying. I think he said, Kerman, you did say that the property is a reverse mortgage. Is that what you said?
Yes.
Okay.
Yes.
So my question about reverse mortgage in this situation, how does that work with a deceased person as far as reverse mortgage?
So, yeah, that's a great question, Aurelia. The reverse mortgage is a little bit unique during the lifetime of the individual, right? Because they're getting a payment from the lender instead of paying the lender. So when a person who wants to stay in their house is an older person, they can get a reverse mortgage and pull the equity out of their house. But a reverse mortgage generally does not allow somebody to pull more than 80% of the value of the house. And there are some maximum limits. I forget what it is now. It's gone up in the last year or two. Might be like $565,000 or something is a maximum amount of a reverse mortgage. When the person dies, the lender ceases any more payments. And then the lender issues a payoff statement on the time of sale, as if it was just a normal loan. So if the house is worth $750,000 and there's a $560,000, let's just make math easy, $550,000 reverse mortgage, the lender gets all of that money back. And then if there's any equity left, it goes to the heirs to the estate. Make sense?
Yes. Could there actually be negative? I mean, could it actually be in the reverse?
It can be. It could happen if property values. So if they lent up to 80% of the value, but then, property values sank, and you had basically an upside down scenario, there can be, but they do not claim. They do not attach against the estate if that happens.
So basically, you won't owe anything on it. You may come out just zero.
Yeah, exactly. The estate will. I mean, of course, the person's dead, but it'll just be zeroed out.
Okay.
Yeah. Great question on that. So we've covered life estates. We've covered some estate questions, capacity questions relating to somebody's mental capacity and what's going to be looked for. I'm going to go back to that capacity question for just a second, because that happens sometimes where settlement people come into my office and say, oh my gosh, this person, I'm not sure of their mental capacity. What do we do? Can they sign these documents? And it's a tough answer, but the truth is nobody in my office and nobody that I'm aware of in your office is capable, right, of determining mental capacity. Unless you have a medical degree in this area, you are not lawfully allowed to determine another person's mental capacity. So if somebody comes into my office and they may be off, or they may be confused about dates or things like that, we're not entitled to tell them they can no longer proceed with their transaction. Now, if they're, obviously completely in an incapacitated or insane type state, then we wouldn't proceed. If they're drunk, if they're obviously high and drunk, we cannot proceed. But if they simply are forgetful or seem like they are not sure about, is today what, Thursday, or is today Sunday? I'm not sure. That does not necessarily mean they don't have the legal capacity to enter into a transaction. That can only be determined by a medical professional or adjudicated in a court of law where the court has stripped a person of their ability to enter into legal contracts and so forth. Does that make sense to everybody? If you do have somebody.
Absolutely. And I have one additional question. I know out of time, but this is important because I had a potential seller that was selling her house. She was exactly like you said. She may be forgetful, but she was in her right mind. Her daughter, then she called her daughter just to make sure, because her daughter wanted her to move, and her daughter said, no, I'm going to list your property. She took her mom and took her to another state. She sold her property under her feet. And she didn't agree to it. And now she's in a place, and she never told her. I was able to tell her that they did sell the house. She never told her what she got. She never told her what happened in her account. And she was very angry about that. She was very upset. And now she's living in Detroit with her daughter. She's called me several times, but I didn't know exactly how to help her. I tried to tell her to contact an attorney. But she's in her right mind, and she was very upset when her daughter just sold the house and never told her the proceeds of what she bought, and the house was paid in full. She didn't know anything in that for that house.
Yeah, that's a tough and a sad situation, Aurelia. And you gave them the right advice. It's, sometimes when people get older, they may want one thing one day, and then the next day they don't even remember they told their kid to do something or not do something. The kid's trying. Maybe the kid is not of good intention, but maybe they are of good intention. It's hard to know. So you gave them the right advice. You've got to see a lawyer in that situation, and then let the lawyer go through all the documents. Were they forged by the daughter at the time of sale? Did the daughter have what's called a power of attorney to sell this property? Did the mother, the older person, come into the settlement table and produce an identification? What happened? So that's a tough situation, and you gave them the right advice. That's the only thing you can do. If you run into one of those situations where maybe you're dealing with an older person and their kid starts calling, unless the older person has given you permission, you really can't talk to the child about the financial issues relating to the sale until you get some written authorization from your client to talk to their kid.
So one more question before you go.
We have Angela Skipper, our amazing agent of the year, has her hand up. So Glenn, after Angela's question, I'm going to go ahead and end the recording, and because we're over time, and I know some folks might have some things to do. So Christian, if you want to hold on, let Angela go, and then once I end the recording, if you want to drop the quick question in for Glenn, and then we'll wrap up after Christian. So Angela.
Okay, thank you, Curtis.
Hi, Angela. How are you?
Hi, Glenn. I'm doing well, thank you. I have a quick question. It just piggybacks on, I think, the first question that was asked regarding valuation. I think the first question was in reference to an estate sale, but if you have let's say a listing and the couple's going through a divorce, is an appraisal always required for valuation, or are there some exceptions to that?
Yeah, that's another really good question. So the appraisal is not always required in a divorce situation. It's required where there may be some contention about the monetary split between the couple, meaning, okay, who gets how much? And when their attorneys or they are fighting in court over how much, spousal support might be required in the separation agreement, a lot of times the value of the house becomes one of issue. It also becomes one of issue if one of the parties is going to buy out the other party as part of the divorce. And so they do an appraisal almost every time in that example where one party is buying out the other party's interest. That's probably what might be going on here, Angela. It is more than likely one party is looking to buy out the other party's interest, or there's a real dispute over marital support and how much that's going to be and who gets what share from the sale of the house.
Okay, so in this situation, the other party is unable to buy out the other one. This property has to be sold. I was just under the impression that in the event that they don't agree on, like if I'm providing let's say a CMA or some form of valuation, one party is, he's agreeing with it, but I assume that if the spouse does not agree, then appraisal may be in order. But
correct.
Okay.
Yep. Yeah, you're exactly correct. So if the parties can't buy the other one out, but they don't agree on the price, and maybe one party wants to hire you and the other party says, well, okay, you might be able to hire her, but I'm not going with her evaluation. I want an independent appraisal. And the attorneys will fight about this a lot, by the way. Do they have attorneys involved in this case?
They do. And as of now, I almost have a listing. I have a signature from one party. And the other one hasn't participated and just hired an attorney. So I'm just wondering, when we will wrap this up.
Well, have you given the party, I guess you've given both of them a CMA?
Absolutely, yes.
Yeah. So as long as your CMA is relatively accurate, the other attorney is probably going to say, yeah, just go ahead. As long as you don't have let's just say, a relationship, a better relationship with one party over the other. You know what I mean?
Yeah, I don't know either one of them. It's just I only have one communicating with me. So
gotcha.
It's a better relationship, no, but definitely I get more insight from one as opposed to the other because there's been very little communication.
Gotcha. Once you do get a listing signed, make sure that you just simply communicate with both parties on every single thing.
Yes.
If you're writing an email to one, copy the other.
Yep, my excellent broker advised that. And
Hey, Jasmine.
Thank you, Glenn.
You're welcome, Angel.
So Glenn, I'm gonna end the recording, guys, real
Good
quick,
thing.
and then we'll have Christian